Welcome to California Bar Prep, your study companion for the California Bar exam. In this lesson, advanced succession, intestacy, ademption, lapse, contests, and omitted heirs. Let's begin. Advanced wills essays are distribution contests. The will may be valid, but a beneficiary died first, the property changed form, a spouse married after execution, a child was born later, or a contestant alleges incapacity or undue influence. California law supplies detailed default rules. Your answer should move from validity to distribution. Identify the estate, identify the governing instrument, adjust for contests and omitted heirs, then apply intestacy or anti-lapse, ademption, and abatement as needed. The California Probate Code is essential. Intestacy begins with Probate Code sections 6,400 through 6,414. Anti-lapse is principally Probate Code section 21110. Omitted spouse rules are in Probate Code sections 21610 through 21612. Omitted child rules are in Probate Code sections 21620 through 21623. Capacity is addressed in Probate Code section 6100.5. Undue influence appears in Probate Code section 86, Welfare and Institutions Code section 15610.70, and related presumptions involving donative transfers. When a person dies without an effective testamentary disposition of some property, that property passes by intestacy. A will contestant may invalidate a will or gift by proving lack of capacity, undue influence, fraud, duress, mistake, or improper execution. Gifts may fail by lapse if the beneficiary predeceases the testator, subject to anti-lapse. Specific gifts may fail or change by ademption if the property is not in the estate at death, subject to California statutory protections. Omitted spouses and children may receive statutory shares unless exceptions show intentional omission, adequate outside provision, or waiver. Probate Code section 6400 provides that property not disposed of by will passes to heirs by intestacy. First, classify property. Community property and quasi-community property follow different rules from separate property. Under Probate Code section 6401, the surviving spouse generally receives the decedent's one-half of community property and one-half of quasi-community property. For separate property, the spouse's share depends on other surviving relatives, all if no surviving issue, parent, sibling, or issue of deceased sibling. One-half if the decedent leaves one child or issue of one deceased child, or leaves no issue but leaves parent, sibling, or issue of deceased sibling. One-third if the decedent leaves more than one child plus issue of deceased children, or issue of two or more deceased children. Probate Code section 21110 provides that if a transferee is kindred of the transferor or kindred of a surviving, deceased, or former spouse or domestic partner of the transferor, and the transferee dies before the transferor leaving issue, the issue take in the transferee's place unless the instrument expresses a contrary intention. This is broad. It is not limited to descendants of the testator. The key questions are whether the beneficiary is within the protected relationship, whether the beneficiary left issue, and whether the instrument shows contrary intent. Ademption concerns a specific gift of property that is not in the estate at death. A specific gift is a particular item, such as my 2020 Tesla or my shares of ABC stock. A general gift is payable from general estate assets, such as $100,000 to Ben. A demonstrative gift is a general amount payable from a specified source, such as $50,000 to Kara from my brokerage account. Classification controls ademption. Traditional identity theory says a specific gift redeems if the item is not in the estate, regardless of intent. California softens harsh results by statute and intent-sensitive exceptions. Probate Code section 21133 provides that a recipient of a specific gift may have rights to the remaining property, balance of purchase price, condemnation award, insurance proceeds, or property acquired as replacement in certain circumstances. Probate Code section 6100.5 provides that an individual is not mentally competent to make a will if, at the time of making the will, the person does not have sufficient mental capacity to understand the nature of the testamentary act, understand and recollect the nature and situation of the person's property, and remember and understand relations to living descendants, spouse, parents, and those whose interests are affected. A person also lacks capacity if suffering from a mental health disorder with delusions or hallucinations that result in a disposition the person would not otherwise have made. Undue influence is excessive persuasion that overcomes the testator's free will and causes a disposition the testator would not otherwise make. California's statutory factors include vulnerability of the victim, influencer's apparent authority, actions or tactics used, and equity of the result. Look for dependency, isolation, secrecy, rushed execution, changes from long-standing plans, active procurement, and benefit to the influencer. An omitted spouse is a surviving spouse who married the decedent after execution of the testamentary instruments and was not provided for. Probate Code Section 21610 generally gives the omitted spouse a statutory share, one half of community property and quasi-community property belonging to the decedent, and a share of separate property the spouse would have received by intestacy, but not more than one half of the separate property estate. Probate Code Section 21611 provides exceptions. The omitted spouse does not take if the omission was intentional and that intention appears in the testamentary instrument, if the decedent provided for the spouse by transfer outside the estate in lieu of a testamentary provision, and intent is shown by statements or amount of transfer or other evidence, or if the spouse waived the right. An omitted child is generally a child born or adopted after execution of the testamentary instruments and not provided for. Probate Code Section 21620 gives the child a share equal to what the child would have received if the decedent had died without a will, subject to limitations. Probate Code Section 21621 creates exceptions. Intentional omission appearing in the instrument. The decedent had one or more children and gave substantially all the estate to the other parent of the omitted child, or outside transfers in lieu of testamentary provision. Lapse versus Ademption. Lapse is beneficiary failure. Ademption is property failure. Capacity versus undue influence. Capacity asks whether the testator could form a plan. Undue influence asks whether someone overcame the testator's free will. Specific versus general gift. Specific gifts are vulnerable to ademption. General gifts usually are not. Omitted heir versus disinherited heir. Omitted heirs are unintentionally left out under statutory assumptions. Disinherited heirs are intentionally excluded. Probate estate versus non-probate transfer. Intestacy and will doctrines usually govern probate property only. Do not apply anti-lapse only to children. California statute protects a broader family class, including kindred of a spouse or domestic partner, if issues survive and no contrary intent appears. Do not say every missing asset addeems. First classify the gift, then check statutory substitutes, unpaid proceeds, replacement property, and incapacity-related sales. A strong conclusion gives actual takers. Spouse takes the omitted spouse share, unless the inter vivos transfer was intended in lieu of a will provision. Anna's gift does not lapse if Section 21110 applies because Anna was kindred and left issue, unless survivorship language shows contrary intent. The car gift deemed if T sold it while competent, but proceeds may pass if Section 21133 applies. Precision wins these essays. That's it for this lesson. Download California Bar Prep on the App Store for lessons on all 14 bar subjects, practice questions, and essay frameworks. Keep studying, and good luck on the bar exam.